Good morning. Honorable Justice B.V. Nagratna, Honorable Judge, Supreme Court of India, Honorable Mr. Justice Ehsanuddin Amanullah, Honorable Judge, Supreme Court of India, Honorable Mr. Justice Sangam Kumar Sahu, Honorable Chief Justice of Patna High Court and Honorable Chancellor of our university, Shri P.K. Shahi, Learned Advocate General, and the member of the General Council and the Executive Council of the University, Madam Alka Sirohi, former Chairman, Union Public Service Commission, Honorable Judges of the High Court, distinguished legal minds, members of print and electronic media, my students, ladies and gentlemen. I stand here to welcome and express my gratitude to Her Ladyship for agreeing to deliver the first Rajendra Prasad Memorial Lecture. I also wish to thank and welcome His Lordship Justice Amanullah for persuading Her Ladyship to accept our request. I am also grateful to my own Honorable Chancellor for gracing this occasion. I also welcome other honorable judges, dignitaries, and of course, our Advocate General, P.K. Shahi sir, who is the true mentor of our university. I also welcome other members of the General Council. I'm grateful to Honorable Justice Sudhir Singh, who not only helped us in organizing 6 convocations in one go, but chaired the Academic Planning Board meeting after 12 long years. His own elder grandfather, Munishwari Prasad Singh, was roommate and batchmate of Dr. Rajendra Prasad, and therefore Justice Sudhir Singh's presence is really significant this morning. Today I speak about a woman whose life story reads like the Constitution itself, layered, principled, evolving, and profoundly committed to justice. She is a judge who has stood alone when the majority was not with her, who has championed the forgotten, who has looked at the grieving mind dismissed as a weakling and said, no, the law must know better than this, and who now stands on the threshold of making the most historic appointment in Indian judicial history. Ladies and gentlemen, I am talking of Justice B.V. Nagratna. She is the daughter of Justice E.S. Venkatramaiah, the 19th Chief Justice of India. But let it be said plainly, she did not inherit greatness, she earned it. In 2021, she was elevated to Supreme Court of India and is poised next year to be sworn in as the 54th Chief Justice of India, the first woman to hold that office in our nation's history. History teaches you that power is never permanent. The institutions rise and fall, not by decree, but whether they serve the people who live under them. That the present is always, always in conversation with the past. And when you carry that sensibility into a courtroom, into the reading of a statute, the writing of a judgment, something shifts. You do not just ask, what does this law say? You ask, what does this moment mean? Who does this decision protect? And who does it leave behind? What will people, a generation from now on, make of what we do today? Justice B.V. Nagratna carried that historian's conscience into every bench she sat on. That's why her judgments so often feel not justly legally sound, but morally complete and upright. A student of history knows that the present is the raw material of the future. And a judge who knows that will never take a decision lightly. A good judge writes for the posterity. What defines a constitutional court's judge is not how many judgments they author, but how they decide the ones that really matter. And what separates Justice Nagratna from the ordinary is not just what she decided, but the person visible in every word she wrote. Let us walk through some of these decisions, not as a list, but as a portrait. When the Constitution bench of Supreme Court upheld Center's 2016 demonetization by a majority of 4-1, In Vivek Narayan Sharma, Justice Nagratna was that one, alone, dissenting. Unlike in Keshavanand Bharati, where there were as many as 6 dissents, she was alone here, like in ADM Jabalpur. She registered her disagreement with the majority, not because dissent was fashionable, but because she believed the rule of law as a component of constitutionalism required such a dissent. A dissent is not law, but an appeal to future generations. A dissent is swimming against the tide. In Mineral Area Development Authority in 2024, a 9-judge bench held that royalty paid by the mining operators is not a tax, and that states have power to levy cess on mineral rights. Justice Nagratna yet again alone dissented, holding that royalty as understood within the framework of MMDR Act is in the nature of a tax, and that states lack the legislative competence to impose further levies. Once again, she sat in a minority of 1. In Rajendra Prasad, another 9-judge bench ruled on states' powers to regulate industrial alcohol. Justice Nagratna was the lone voice in 8-1 verdict. She meticulously distinguished between entry 8 of list 2, dealing with intoxicating liquors, and the field occupied by Parliament under entry 52, refusing to allow the constitutional text to be stretched beyond its frame. 3 constitutional benches, 3 dissents, each one a reminder that the highest form of judicial courage is not agreement with the majority, it is fidelity to principle. She does not merely interpret the Constitution, but feels it, believes in it, lives it. When I am saying she lives it, the reflection of this phrase shows how she acted not just for the procedural safeguards, but for the dignity of the individual. In Vijaya Kumari, Justice Nagratna confronted one of the most intimate intersections of law and life. 3 sets of couples had begun their surrogacy journeys years before the Surrogacy Regulation Act 2021 came into force. They had visited clinics, undergone counseling, fertilized embryos, and frozen them, all in preparation for the final step of transferring these embryos to a surrogate mother. Then the law arrived, and with it, the age restrictions. The Union of India argued that Act applied fully from its date of commencement, and the couples who had now crossed the prescribed age limits were ineligible. Justice Nagratna looked at this argument and held it could not stand. She grounded her reasoning in Article 21 of the Constitution in recognition of long-established practice of the Supreme Court that reproductive autonomy is part of constellation of rights afforded to all persons. She held that right to make autonomous decisions regarding surrogacy and vested in these couples before the Act came into force. The freezing of embryos was not a preliminary step, it was the crystallization of intention. All that remained was the involvement of surrogate mother herself. At this threshold, she held, the Act could not reach back and say, you are too old. The writ petitions were allowed. The couples were exempted from the age bar. The law, Justice Nagratna reminded us, must not punish hope that has already been acted upon. The list is too long, and time given to me is not in proportionate to justify and reflect the true being of her. What makes Justice Nagratna remarkable is not just the verdict she has delivered, but the values she has expressed within them, sometimes in the quieter moments that do not make newspaper headlines. I want to quote from her judgment when she was sitting in the Karnataka High Court, and I quote, "There can be illegitimate parents, but no illegitimate children," unquote. Perhaps no phrase from Justice Nagratna's pen captures her humility more completely than this. I have invited her to deliver the first lecture of this prestigious series because of this one statement of her historic judgment, as these words reflect a whole philosophy of dignity. A Supreme Court judge who believes in human dignity has the right to speak on constitutionalism beyond rights, as we today prefer to talk more about duties than rights. Even in the United States, freedom of speech in university campuses has been lately curtailed. In India, courts no more treat habeas corpus petitions as important, as such petitions used to be treated in good old days. They routinely give long dates and at times do not give verdicts prior to transfer or superannuation after long hearings, necessitating full rehearing. Supreme Court's own jurisprudence on bail, I'm sorry to say, is consistently inconsistent. Justice Amanullah is son of soil, a bold and fearless judge who has all the qualities of an ideal judge. His order on private universities has sent shock waves in the higher education sector. A judge for whom the ropes of justice are not made for comfort, they are made for truth. CNLU can never thank him enough, as he is basically leading CNLU's current transformation. I am just giving effect to his vision to see CNLU in the top league of law schools. I welcome his lordship. Our beloved and extremely humble Chancellor too is a judge who prefers to speak only through his verdicts. He is not keen to capture newspaper headlines and is more interested in dispensing justice. Indeed, the deepest rivers make the least noise. Depth, whether in water or human character, is characterized by peace and strength. It is shame that we have forgotten one of the most illustrious sons of Bihar and India, Dr. Rajendra Prasad, who not only was a great statesman, but a lawyer of great eminence. His memo of second appeal preserved in Patna High Court Museum is a model. He never raised more than one question of law in the second appeal. Dr. Rajendra Prasad was elected unanimously as the president of the Constituent Assembly which framed India's constitution. Dr. Prasad became the first and the longest serving president of the Republic of India. He was the president of India from 1950 to 1960. Dr. Prasad's role in Mahatma Gandhi's Champaran Satyagraha in 1917 is far too well known to be explained in any detail. Dr. Rajendra Prasad was a mainstay of India's freedom struggle for independence led by Mahatma Gandhi. He was part of Champaran Satyagraha. He took part in non-cooperation movement. He took part in Gandhian constructive program, in the civil disobedience movement. He became the president of Indian National Congress in 1935, participated in Quit India movement. As a student of constitutional law, I believe that if I don't say a few words on the topic, my students would be very unhappy and I can't really make them unhappy. Man since antiquity has pondered the problem of how to reconcile the need for order and authority in society with the desire for individual liberty. In framing a government which is to be administered by men over men, the greatest difficulty accordingly lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Humanity has always had a longing to be free in addition to being well governed. As a result, a great deal of thought and political inventiveness has gone into an attempt to create political systems that will allow governments and its organs to exercise all the power that is essential to attain the collective ends of the society without at the same time either compromising or destroying the liberties of its individual members. Such an attempt to institutionalize such a social condition is being termed as constitutionalism, the concept of limited government. Constitutionalism is just like religion, aimed at bringing coherency to seeming chaos, supplying a set of beliefs that seek to canalize human conduct. Western institutional theorists have concerned themselves with the problems of ensuring that the exercise of governmental powers, which is essential to the realization of values of their societies, should be controlled in order that it should not itself be destructive of the values it was intended to promote. Should it be controlled just through people's rights or something else is the central question on which her ladyship is going to speak today. We have seen the lofty ideals which normative concept of constitutionalism was developed. If constitutionalism is to be defined fully and accurately, we should view it sociologically and look at it in the action, particularly from the perspective of its social purpose. As we have seen, most commentators define the terms normatively. Thus, Professor Walter F. Murphy says, the fundamental value that constitutionalism protects is human dignity. And that's why her ladyship is here. Murphy differentiates two quite different political theories, democracy and constitutionalism. The democratic genes stress popular rule and processes to effectuate that rule. The constitutional genes emphasize individual liberty and limitations on government power, even when it is responding to public opinion. Democracy is ruled by majority, but not majoritarianism. Today, democracy is dying in several continents of the world. The age of martial law and military coup is over. The threat is not from the bullet of a military general, but from the ballot itself. Unfortunately, the death of constitutionalism is the central event of our time, just as the death of God was that of 19th century. There can be little question that constitutions, including that of United States, are tilting towards authoritarianism, and thus are undercutting constitutionalism as a limitation on government. Perhaps they were actually always authoritarian in their operational code and has merely become more apparent, merging with the myth system. Professor John Griffith of London School of Economics so contends, societies are by nature authoritarian, governments even more so. The widely held belief that sovereignty resides in the people who delegate it to politicians to hold in trust for them is for Griffith a bit of a nonsense, a cover-up for authoritarianism. Thus, it is argued today, most Western constitutions, including that of United States, are only ostensibly one of rights and limitations. In fact, they are all one of powers and control. The 19th century constitutional state was, in fact, as a part of a myth system. And that, I believe, is a question which her ladyship is going to answer today. Constitutionalism beyond rights as the focal point of engagement must not be divorced from the idea of rights. It should ideally be divorced from the idea of enforcement of rights through courts. Constitutionalism must be inculcated as a habit by the citizens of liberal democracies. Finally, the issue of strengthening the neutral executives or the fourth branch or the guarantor institutions or watchdog institutions under the Constitution is important. The case for ensuring the independence of institutions like Election Commission, CAG, Lokpal, etc. must be given utmost importance if constitutionalism has to prosper in India. The present system of administrative control over these institutions does not inspire much confidence in their independence. Let us listen to our honorable judges and her ladyship. I don't want to stand anymore between you and her ladyship. Long live constitutionalism. Jai Hind, Jai Bihar. Thank you very much. May I now request her ladyship to deliver the first Rajendra Prasad Memorial Lecture.
Namaskar and a very good morning to everybody. My esteemed brother, Justice Amanullah, Judge, Supreme Court of India, Honorable Sri Sangam Kumar Sahu, Chief Justice, Patna High Court and Chancellor, Chanakya National Law University, Patna, my brother and sister judges of the Patna High Court, Sri P.K. Shahi, Learned Advocate General, Government of Bihar, Sri Faizan Mustafa, Vice Chancellor, CNLU Patna, members of various councils of CNLU, learned senior advocates and advocates, Madam Alka Sirohi, former chairperson UPSC, distinguished invitees, learned faculty, scholars and professors, My dear students who are here present in large numbers, members of the media, ladies and gentlemen, I am very happy to be in Patna as it is my first visit here to this ancient city of Pataliputra. As a student of history, I remember the great rulers of this region, Chandragupta Maurya being one of them. He was aided by none other than Chanakya or Kautilya, after whom this university is named. Chanakya Niti or Kautilya's Arthashastra is still relevant today as it was in the earlier days, and it must be read by everyone who wants to be and is in public service. Ashoka's Dhamma theory is something very close to my heart. As a student of history, I may say that Dr. Romila Thapar has written a volume about Ashoka, and I have read that book cover to cover at least twice in my first year as a history student. As I say again, that it is a great honor and prestige for me to be in this audience to deliver the very first Rajendra Prasad Memorial Lecture. I thank my brother judge, Justice Amanullah, the Chancellor, Chief Justice Sahu, and the Vice Chancellor of this university for having invited me to address this august gathering. This is an occasion dedicated to remembering a life that so profoundly shaped the intellectual, constitutional, and moral foundations of our nation. Dr. Rajendra Prasad was the first President of the Republic of India and the head of our state for an entire decade. Prior thereto, he was the President of the Constituent Assembly, where he presided over the proceedings of the Assembly and oversaw the work of numerous committees dedicated to the framing of our Constitution. He was born on 3rd December 1884 in Zerade, now in Siwan district of Bihar. His birthday is celebrated as Adhivakta Divas or Advocates Day. From an early age, Dr. Rajendra Prasad's intellectual promise was evident. I was just reading his, you see his profile and how much he had studied. In 1902, he joined Presidency College, Calcutta, enrolling as a student of science. So exceptional was his performance that an examiner famously remarked on his answer sheet, quote, "The examinee is better than the examiner," unquote. Choosing to broaden his intellectual horizons, Dr. Prasad shifted from science to arts. He pursued economics and completed his MA with the first division from the University of Calcutta in December 1907, marking the beginning of a lifelong engagement with ideas, education, and public service. Yet, learning was not a closed chapter for him. Leaving behind his professorship in English at Muzaffarpur, he chose once again to become a student, and this time in law. He enrolled at Ripon College, Calcutta, now known as Surendranath Law College. In 1911, Dr. Rajendra Prasad joined the Calcutta Bar. Alongside his practice, he continued to teach, serving as professor of economics at Calcutta City College in 1909. His academic brilliance reached another milestone in 1915, when he appeared for the master's examination in law from the Department of Law, University of Calcutta, secured the first prize and was awarded a gold medal. He later completed his doctorate in law from Allahabad University. In 1916, Dr. Prasad joined the Patna High Court, marking the onset of a distinguished legal career in the High Court and also before the Privy Council. Even as a junior, his drafts and case notes were so precise and persuasive that they earned admiration from legal stalwarts like Sir Rash Bihari Ghosh, who recognized him as a lawyer of precision and not verbosity. What truly set him apart was his remarkable restraint. He would often rest his entire case in a second appeal on a single or only two substantial questions of law. The Vice Chancellor just mentioned this. This aspect has always impressed me because my father used to mention to me about Dr. Rajendra Prasad that when you are arguing a second appeal, you concentrate on the substantial question of law and not on the facts. Because the finality of facts would have attained in the first appellate court. And all that you must concentrate is on substantial question of law under section 100 of the Code of Civil Procedure. This has impressed me that as a judge in the Karnataka High Court, I would give keen attention to the arguments of the advocates to ultimately crystallize a substantial question of law in a second appeal to two and very rarely three questions or substantial questions of law. Equally striking was his unwavering professional integrity. Even at those times, I am not saying now, even at those times, lawyers tried to cultivate familiarity with judges, which is not a new thing now, outside the courtroom. Dr. Rajendra Prasad held firmly to principle, meeting judges only in the court. This drew praise from none other than Chief Justice Sir Lawrence Jenkins, who recognized in him a person of exceptional integrity. I must congratulate this university for having taken up of institutionalizing his name and perpetrating his memory by having this lecture series. And I once again say that I am humbled by being invited to deliver the very first lecture. Dr. Rajendra Prasad also played a prominent role in India's struggle against colonial rule, including the first Satyagraha movement in British India under Gandhiji's leadership, the Champaran Satyagraha in Bihar, where the farmers were protesting against having to grow indigo with hardly any payment in return. After the formation of the interim government in 1946, Dr. Prasad served as the Food and Agriculture Minister, a ministry he held even after independence in 1947. He also had the distinction of being the President of the Constituent Assembly of India from 1946 to 50. And on 24 January 1950, after 2.5 years of our independence, the Constitution of India was ratified and Dr. Prasad was elected as the first President of the Republic of India. He was re-elected for 2 consecutive terms in 1952 and 1957, which is a distinction which is unmatched in Indian history till date. He laid the foundation for the nation to become a full-fledged republic as the head of the state. Dr. Rajendra Prasad demonstrated his constitutional role as the President of the Republic through a few notable episodes, one being his disagreement with the Hindu Code Bill, but later Prime Minister Nehru said that he would move that bill and ultimately it was moved. He also was against government policy on the state trading in food grains and also land sealing. There were also times when he said that the Parliament did not have the competence to pass the PEPSU appropriation bill and he vetoed it. The only other veto in Indian history is when President R. Venkatraman exercised a veto in 1991 regarding the salary allowances and pension of members of Parliament amendment bill and withheld assent to that. In this way, Dr. Rajendra Prasad used his discretion and recognized that he had certain powers which could be exercised independently of ministerial advice. Speaking at the inauguration of the Bar Association of India in New Delhi on 2nd April 1960, Dr. Rajendra Prasad, as the President, said, and I quote, "It is almost the daily experience of all of us that acts and legislations passed by the Parliament are brought before courts on which they have to pronounce whether they are valid or they are not valid, whether the Parliament had the right to pass that particular law, or it did not have the right, whether it had exceeded its jurisdiction or it had acted within its powers. If that is so, then we must realize that the Constitution, for that very reason, divides the functions of the various organs of the state, and it makes each organ more or less self-sufficient and independent in its own sphere. If the legislature is independent in its sphere, the judiciary is equally independent in its own sphere. While one cannot and ought not to interfere with the activities of the other, each one has certain restraints which it has to put upon itself in order to be able to act justly and fairly, so that the work may proceed without any difficulty and without any obstruction. The whole Constitution therefore envisages checks and balances, so that unless each acts within its own sphere limited by the Constitution, and even more so limited by its own sense of dignity and sense of restraint, the work of the Constitution cannot get on well, unquote. With these words, I speak on the topic, Constitutionalism Beyond Rights, Why Structure Matters. The quotation which I have just rendered is the inspiration for the speech which I would now deliver. We all know that the Constitution of India is a transformative document. It transformed the legal relationship between the individual and the state. The subjects of a colonial regime became overnight the free citizens of the Republic. In that sense, the Constitution placed the colonial logic of governing the population with the democratic logic of popular sovereignty and public participation. This transformation was expressed essentially in the Fundamental Rights chapter of our Constitution. These rights represent restraint against state action, but are also subject to reasonable restrictions. The Indian Constitution was transformative in a second sense. It contemplated a thorough reconstruction not only of the state, but of the Indian society too. The Constitution recognized that the state had never been the only focus or locus of concentrated power in Indian society. Deeply pervasive hierarchies were maintained by structures that took various forms, such as class, caste, etc. Therefore, the Constitution also housed horizontal rights provisions, fundamental rights enforceable against groups, communities, and even private individuals. Some examples are in Article 15(2), Article 17, and 23. These provisions in turn are concrete expressions of our preambular values of liberty, equality, fraternity, and justice. They give effect to political, economic, and social justice. Yet the thrust of my lecture today is not on rights, but on structure under the Constitution. History teaches us that without structural safeguards, even the most carefully framed rights and guarantees may yield to the pressure of power. The Vice Chancellor just now said that history is replete with examples of constitutions that promised equality, liberty, dignity, and many other freedoms, and delivered none of them. Worse still, many constitutions of the world have actively violated them. Therefore, rights without structure risk becoming what James Madison famously called only parchment guarantees, promises written into the text but unsupported by the organization of power. The real constitution of any polity lies not only in the rights it declares, but in how it distributes limits and disciplines power or authority. With that understanding, the question before us is not simply what values the Constitution proclaims, but what must remain structurally operative for those values to endure. Does Parliament possess the authority to alter the constitutional order in whatever manner it deems fit? I need not go into the details to this enlightened audience who are well versed in law about the early decisions of the Supreme Court in Rajendra Prasad, Sajjan Singh, and Golaknath. When in Golaknath they said that the attempt to impose limits on the amending power must be recognized. The Parliament responded with a swift 24th Amendment, and it restored its authority by stating in Article 13 that it shall not apply to any amendment of the Constitution made under Article 368. But even then, earlier, in Sajjan Singh's case, Justice Mudholkar had raised this issue as to whether structural limits must be there, which is internal to the constitutional design itself. Can the Parliament amend the Constitution in such a way that its essence itself is no longer recognizable? Therefore, in this context, the Supreme Court in Keshavananda Bharati said that the fundamental rights could not be amended. The Supreme Court came up with a basic structure theory and said that it was whether the Constitution by design imposed limits on the power of amendment was gone into. And the court said, yes, internally, inherently, there is a limit on the Parliament to amend the Constitution. The Supreme Court in Keshavananda Bharati rejected two extreme propositions. One was that the Constitution was entirely unamendable. The second was that the amending power was unlimited. Instead, the basic structure theory was propounded to have a middle path, that the Constitution may be amended, but it may not be so amended as to erode its basic structure. This is the essence of the basic structure doctrine. Basic structure is not a doctrine of rights. It is a doctrine of structure. The concept of separation of powers, which is a basic feature of the Constitution, envisages a system of checks and balances by which the powers distributed to each of the organs of the government do not predominate or disable the other organs from exercising and discharge the powers and functions entrusted to them alone. At the heart of this design lie two interlocking arrangements, which I would call as the horizontal separation of powers between the legislature, the executive and judiciary, and the vertical division of powers between the central, the state and the local governments. Horizontal separation of powers. At the horizontal level, the Constitution allocates authority among three coordinate institutions. The legislative power is vested with the Parliament, the executive power is formally vested in the President and in the state governor in the states, and the judicial power is vested in the Supreme Court and the High Courts. This distribution reflects a foundational commitment that the functions of making law, executing it, and interpreting it should not be concentrated in a single authority. But the Indian Constitution does not adopt a rigid separation. Instead, it creates a system of structured interdependence in which each branch both exercises power and remains restrained by another. Consider the first, that is the legislature. Parliament is the primary site of democratic authority. It represents the will of the people and enacts laws that govern the life of the nation. Yet its power is not unbounded. It is subject first to substantive limitations under Article 13, which invalidates laws that contravene fundamental rights. Second, it is subject to structural limitations arising from the federal distribution of legislative competence under Articles 245 and 246 and the subjects mentioned in the three lists of the 7th schedule. And finally, it is subject to the independent judicial review under Articles 32 and 226 of the Constitution. I need not go into the details of this by citing the cases of Minerva Mills, Keshavananda Bharati, Indira Gandhi, Nehru, etc. But I would say that the clear structural principle at play here is that even the democratically elected legislature does not operate in a space of unrestrained authority. Next, the executive. The executive, which is the most immediate wielder of state power, is similarly structured. It is the executive that makes decisions, enforces laws, and directly affects the lives of individuals. From arrest and detention to licensing, taxation, and regulation, it is the executive action that most frequently constitutes the citizen's encounter with the state. For that very reason, the Constitution does not leave the executive power unconfined. It subjects it to multiple overlapping forms of accountability. At the political level, the executive is rendered answerable to the legislature through questions, meaningful debates, motions, and ultimately the possibility of a vote of no confidence. Executive action is exposed to scrutiny in the legislature and must be defended in a public representative forum. Therefore, the importance of debates in the parliament or legislature in the states. This would in turn result in the expectation of the citizens being assuaged by the members who discharge their constitutional duties in a representative capacity. I may say here that the citizens of this country are yearning for debates to take place in the parliament or in the state legislatures, rather than there being only walkouts and there being unilateral approval or passing of the acts and the bills. But political accountability, while essential, is not sufficient. The Constitution reinforces it through legal accountability too. Executive action is therefore subject to judicial review under Articles 32 and 226, ensuring that it conforms not only to statutory authority, but to constitutional limitations, inter alia under Part 3. In this sense, executive authority is not merely exercised. I would say it is disciplined. You would all be aware of various principles under administrative law, which are the grounds on which an administrative action can be challenged either before the Supreme Court or before the High Court. It operates within a framework that demands justification at every stage, political, legal, and procedural. And it is this requirement, this insistence, that power must always answer to law that gives meaning to constitutional guarantees. Next, judiciary. The judiciary in turn occupies a distinctive position within this structure. It is entrusted with the role of interpreting the Constitution and ensuring that all public power conforms to its limits. The Supreme Court's authority under Article 32 has been described by Dr. B.R. Ambedkar as the heart and soul of the Constitution, placing it at the center of constitutional governance. Yet, judicial power is not outside limits. It is within its limitations in the following ways. Firstly, it operates within the text of the Constitution. The court does not claim authority beyond the Constitution. It claims authority because of it. Interpretation does not mean substitution of judicial authority. It is always a question of reviewing whether administrative action has been just, unfair, or fair and in accordance with law. Secondly, judicial decisions may be altered through amendments made by the Parliament, which is on the principle of abrogation of a decision, subject, of course, to the basis of the decision being effaced by a parliamentary amendment or a legislative amendment in the State Assembly. And finally, judicial authority is not self-executing. Its authority ultimately depends on compliance by the executive. Even where the court has issued wide-ranging directions, the success of those directions is dependent on executive implementation of the same in a practical manner. Therefore, we judges must be careful while issuing directions. Are these directions implementable? Are they practical? Or are they something which the legislative, whether the executive cannot implement? On the other hand, it is the duty of the executive also to implement the directions of the judiciary or the courts. Otherwise, we all know they are liable for contempts. And many of us will go slow on contempts because ultimately We want our directions to be implemented and not to punish anybody. But the duty of the executive to implement the directions, unless they are appealing against them, is strict. This does not diminish the authority of the judiciary. It situates it. The judicial authority is real. Its role is central and balancing. Its power is significant, but only neutral and not self-executing. What emerges from the above discussion is that the Constitution does not repose trust in any single institution. It relies instead on a system in which each institution restrains the others and in turn is restrained by the others. This sometimes results in a friction, but it is designed that those frictions are ultimately to ensure that there is no impulsive or concentration of power in majorities. Power that moves unchecked moves quickly, but power which must answer, explain, and defend itself will move slowly, but also carefully. The slower movement of power is not a defect, it is a safeguard, because it is after a realization, after a contemplation, that a decision is taken. I next move on to the vertical division of power. The Constitution reinforces this relationship through the division of legislative powers between the Union and the state legislatures. Article 245 and 246 and the 7th schedule of the Constitution distribute the subjects. We all know that list 1 is the Union list, list 2 is the state list, and list 3 is the concurrent list, and the subjects which are placed in those lists depend upon whether they are of national importance or of regional or state importance, and certain subjects where even the Union as well as the state assemblies would exercise their jurisdiction, subject to Article 254(1) and Article 254(2) of the Constitution. This arrangement reflects a deeper structural arrangement. By allocating powers to different levels of government, the Constitution ensures that no single center can monopolize political power. Excuse me. This insight bears close parallel to the American understanding of federalism. As Madison explained in the Federalist Papers, the division of power between the federal government and the states provides a double security to liberty. Federalism in this sense is not only autonomy, it creates distinct centers of power, each capable of acting as a counterweight to the others. It ensures that governance is not a matter of unilateral command, but of negotiation and coordination. Therefore, the need of the hour is to have greater coordination between the Union and the state governments. The state governments are not subordinate to the Union government except as stipulated under the Constitution, and therefore must be accorded treatment that is due to them, irrespective of the political parties that may be in power. Inter-party differences or distinct political ideologies have to be kept aside in the matter of center-state relations, as the latter is in the realm of constitutional governance, which would not depend on which party may be ruling at the center and which other party may be ruling at the state level. The citizens must have the benefit of both governments, and with regard to the welfare of schemes and measures that are initiated by the respective governments. That is why it is often said that the Constitution of India is said to be federal in structure and unitary in spirit. Therefore, the citizens cannot be discriminated against in matters of development or in governance. There cannot be a pick and choose approach vis-à-vis the states when it is in the realm of development programs for the citizens of a state. Equity as a matter of fair approach must be adopted. Similarly, between states, the relations must be cordial and in accordance with constitutional dharma. There must be an approach of accommodation and understanding between the states so as to arrive at a consensus in the first instance, rather than filing suits for various reliefs before the Supreme Court. Mentoring of states by the central government, mediation of disputes such as border disputes or water disputes between states would result in positive outcomes rather than to indulge in litigation as adversaries. Thus, increase in conflict between the states of the Union or between center and the states does not augur well for the nation. This creates a dent in constitutional form of governance, which must be avoided always, for the strength of the nation is based on constitutional foundation and principles. A mature federation ought not to rush to courts as adversaries. Instead, it should turn to dialogue, negotiation, and mediation. When states begin filing cases against one another or against a center, it reflects not strength, but a weakening of cooperative federalism. Issues such as border disputes or water sharing disputes are too complex, sensitive, and enduring to be reduced to adversarial litigation before the courts alone. In equal measure, the center ought not to view the states as coordinates and not subordinates. Keep it here. I'll drink it. If you permit me, I'll just have some water. When states begin filing suits against one another or against the center, it reflects not strength but a weakening of the cooperative federalism. In equal measure, the center ought to view the states as coordinates and not subordinates. No doubt the Constitution of India is said to be federal in structure and unitary in spirit. Yet the vertical separation of powers between governments, center and states is not a hierarchy or a priority. It is a constitutional arrangement of co-equals. I need not go into the details of the 73rd and 74th constitutional amendments, where the power structure is arranged vis-a-vis panchayats and municipalities by amendment of Part 9 and Part 9A of the Constitution. The idea is to bring governance closer to the people and to create additional layers of direct accountability. But beyond this horizontal and vertical separation of powers, there is what is called the fourth branch institutions, which the Vice Chancellor mentioned. Power is not exercised through formal institutions. It is exercised through processes that sustain them: elections, public finance, and regulation. A set of institutions, while not always fitting within the classical tripartite scheme, are nonetheless central to the maintenance of constitutional order. We all know that Article 324 of the Constitution constitutes the Election Commission of India, which is entrusted with the superintendent's direction and control of elections. Elections in India are not merely periodic events. They are a mechanism through which political authority is constituted. Our constitutional democracy has amply demonstrated smooth changes in government due to elections being held on a timely basis. Control over the process is, in effect, control over the conditions of political competition itself. In T.N. session, the Supreme Court said that the Election Commission is a constitutional authority of high significance, entrusted with ensuring the integrity of election. The concern here again is structural. If those who conduct elections are dependent on those who contest them, the neutrality of the process cannot be assured. A similar logic applies to the Comptroller and Auditor General of India. Without independent oversight, fiscal decisions may escape scrutiny and obscure accountability. Therefore, the CAG introduces an external audit into this domain, ensuring that public expenditure is examined not by the legislature or executive who incur it, but by an independent authority. We also have the Finance Commission under Article 280 of the Constitution, which deals with fiscal independence, which is not dependent on political dependence. By entrusting this function to the Finance Commission, resource allocation is guided by principles rather than political advantage. Here again, the objective is structural, to prevent the consolidation of power through control over fiscal flows. These institutions share a common logic. They are insulated, specialized, and tasked with overseeing domains where the ordinary political process may be insufficient to ensure neutrality. Similarly, we have the Public Service Commission at the Union as well as the states. It is of utmost importance that these institutions function independently and not be influenced by any political process. Along these, we have the Competition Commission of India, we have the Securities and Exchange Board of India, Telecom Regulatory Authority of India. All these are ultimately headed by the members and the chairpersons in the tribunals who adjudicate their disputes. The Supreme Court has said that these tribunals and adjudicatory bodies must have, quote, the independence of members discharging judicial functions in a tribunal cannot be diluted. Tribunals should have members, persons of a rank, capacity, and status as nearly as possible equal to the rank, status, and capacity of the court, which was till then dealing with such matters. And the members of the tribunal should have the independence and security of tenure, associated with judicial tribunals. Members who are experts appointed to the tribunals cannot overpower the judicial members as such. I am saying this with regard to technical members. They are appointed to the tribunals due to their expertise, but the judicial member always proceeds having regard to all angles that are applicable in law, and therefore there has to be a coordination between the technical members and the judicial members in a tribunal. In closing, I would say that ultimately constitutionalism is not merely what the state must do, but how it must act. The durability of the rights depends on the integrity of the institutions that interpret and enforce them. In that sense, good structure is not ancillary, but foundational, because good structure is also important for good governance. I must take inspiration from Kautilya or Chanakya, from whom your institution derives its name. In his Arthashastra, he said, without government rises disorder. Matsya bhavayati, that is, law of the fish, law of the jungle, state of anarchy. In the absence of governance, the strong will swallow the weak, but in the presence of good governance, the weak will resist the strong. It is in this context that the directive principles of state policy assume critical importance as a complement to rights, but grounded in structure. The directive principles are many, but I would refer to only Articles 38, 39, 41, 42, 45, and 47. Article 47 places a duty on the state to raise the level of nutrition and public health. Without childhood care, nutrition, and good health, the future generation of the nation would not be strong. For a strong India, we require a strong human resource. And for a strong human resource, public health and education of the citizens are essential, especially of our children. For that, the child must have nutrition, which is most important, as it helps it develop both physically and mentally, and thus could contribute to the nation. Yet, the Constitution deliberately renders these directive principles non-justiciable. This is not because they are less important, but because their realization depends on complex, resource-sensitive, and policy-driven decision-making tasks that require legislative deliberation and executive expertise. Adherence to this structural discipline is what enables the meaningful pursuit of these directives. It is when each organ of the Constitution operates with its designated sphere that governance under the Constitution will become more sustainable, coherent, and democratically legitimate. This would, as a consequence, reduce litigation, reduce the burden on courts and tribunals, and as a judge, I would say, reduce the pendency of cases in courts. The former World Bank President Barbara Conable said, good governance means a public service that is efficient, a judicial system that is reliable, and an administration that is accountable to its public. It is also defined as the manner in which power is exercised in the management of a country's economic and social resource for development. According to Kautilya's Arthashastra, good governance was the central aim of a king's responsibilities. Up to this point, I have discussed about the principle of structure, but what happens in experience and in practice? This is the crucial insight. Constitutional identity can be lost without constitutional invalidity. Constitutional breakdown can occur within legality through gradual hollowing out of structure where rights exist formally untouched. The unmistakable lesson of history is that constitutional collapse occurs through the disabling of its structure, and the violation of rights merely follows later. The dismantling of structure in turn occurs when institutions stop checking each other. In that moment, elections may continue, courts may function, laws may be made by parliament, and yet power is effectively not restrained because the structural discipline no longer exists. The preservation of the Constitution cannot be understood solely as the task of defending rights at moments of crisis. It lies equally every day, routine functioning of institutions, in whether each organ of the state continues to act within its sphere, respects the limits of its authority, and remains conscious of the role it plays within the larger constitutional arrangement. It lies in whether the Election Commission conducts elections with independence that inspires trust, whether the Finance Commission preserves fiscal balance without yielding to unitary pressures, whether regulatory bodies such as the Competition Commission of India and SEBI act with neutrality rather than on executive preference, whether the legislature deliberates on forthcoming laws rather than merely stamps approval, whether the executive governs within law rather than over it, and whether the courts remain anchored at all times in the discipline of the Constitution, which includes independence. But when independence yields to convenience, when accountability gives way to expediency, when limits are treated as obstacles rather than safeguards, the structure begins to loosen and crack. I conclude by saying that the Constitution is not self-sustaining. It is sustained through practice, through institutional fidelity, and through restraint in the exercise of power. Power, no matter however legitimate in its source, must always remain answerable. One should seek inspiration from Dr. Rajendra Prasad, the first President of the Republic of India. While laying the foundation stone of the new building of the Supreme Court of India on 29th October 1954, he said, and I quote, "The division of functions of the state does not and ought not to mean any conflict between the various organs. They are all the organs of one entity, the state, and each has its own functions to perform, which it should be free to perform, and in the performance of which there should be no interference by any other." With this, I once again thank the Chancellor, my learned brother, Justice Amanullah, the Vice Chancellor, for inviting me to deliver this prestigious address. I congratulate the university for instituting this address in the name and memory of Dr. Rajendra Prasad. I thank you all for sparing this Saturday morning and being present here. I thank you all for your kind attention. Namaskar.
Thank you very much. What a treat it was. Constitutions in themselves may not achieve the goal of constitutionalism if the structures are not there. And a very pertinent observation, because we are going to have elections in some states, that if the election commission, which conducts election, itself depends on those who contest elections, then its own independence will always remain in doubt. We are really honored, and it was privilege listening to her ladyship. A university is all about students. I have said it 100 times. And therefore, generally in memorial lectures, though questions are not taken, historically speaking, but we would prefer to take few questions. I have persuaded her ladyship to answer those questions. So can we have raise of hands, maybe 5, 6 questions? Yeah, let's start from the last one, yeah?
Nothing which is...
The last man in the row. Be very brief and pointed. If it is a comment, it should be extremely short.
Hello. So first of all, your ladyship,
Stand up, stand up, stand up.
I respect
It
the
is not my class where you can remain sitting.
latest dissent which you have given in the collegium, and I really respect you for that. So my question is about structures. When you said that constitutionalism, it binds all the 3 horizontal division of power, judiciary being one of them. But in the last 20 to 30 years, a trend has been seen where some cases get in front of certain bench, and judges and the mentioning of cases becomes predictable, that this will be the judge who will get the case and this will be the judgment. It has become little predictable. So what are the structure does the judiciary has in itself to avoid
Yeah, I got your question, but let me reframe. Mentioning is not there. It's the whole question about the master of roster. While there is absolutely no denial of a fact that the Chief Justice has to be a master of roster, and it has worked very well in high courts. But there are people now who say that how the case goes to X bench, one can always make a prediction about which way the case will go, because at least Chief Justice, by working with brother and sister judges, knows about what is they are thinking. So I had also written some time back, can we even about this power, ultimately constitutionalism will apply on everyone. So Supreme Court is also not supreme. It is supreme in terms of jurisdiction, but ultimately Constitution is supreme. So can we say that the senior most 3 judges, Chief Justice plus 2 judges, will decide the roster, at least in contentious questions, or should we leave it just to the Chief Justice?
No,
that is what he's asking, but I would say let us take 2, 3 questions. So
No,
that
I'll
we
just
can...
answer one
Okay,
by one.
please.
See, the first thing is the Chief Justice, whether of the High Court or of the Supreme Court, is the master of the roster. Nothing more can be said about it. Once he assigns the cases to a particular judge, so many cases go in terms of what is called roster, subject roster. There are some cases where the matters are assigned depending on the wisdom of the Honorable Chief Justice, whether of the High Court or of the Supreme Court. Thereafter, he has no say in the matter. It is for that particular bench to ultimately decide. Did anybody predict that I would dissent in so many cases? Ultimately, it is the thinking, the conviction, independence, and courage of the individual judge who hears that case, who ultimately decides. So therefore, we cannot say that if this matter goes before this judge, this will happen. That is not a correct assessment at all.
Correct. Next. Yeah, red shirt, red t-shirts, please go ahead.
My question sprouts from the comment of Professor Mustafa that bail is consistently inconsistent. I present
But
a
you have
case.
to ask questions about the lecture, not on my welcome address.
Yes. On the lecture, that Siddiqui Kapan and the case study of Arnab Goswami, Siddiqui was charged with PMLA, UAPA, sedition, spreading hate on grounds of religion, just trying to report on the Hathras case. While Arnab Goswami, a celebrity news reporter, his case shot up to SCI, releasing him on bail in 3 days. Siddiqui, in that time, faced 3 years of hell, where he was jailed under trial,
Okay,
still
you made your
making
point.
trips
Let's not go into
Yes,
individual
yes, yes.
cases. We are on the jurisprudence.
Yes, so I ask in the esteemed knowledge of yours, what SCI's standing on bail matters is. When SCI refuses to interfere in bail matters, sometimes as given by the High Court in Vadodara crash case, and sometimes on prompt notice holds hearings of some privileged cases. Since we are discussing on structure, what is the SCI structure that it follows? And in such structure, how the weak shall resist the strong? Given that we do not have good governance, as we assume, in these years. Apologies if I hurt someone's sentiments.
All
Thank
right,
you.
it has to be brave. The question which you need to understand, there is no one Supreme Court. There are multiple Supreme Courts because they sit in 2s and 3s. So there can be a very liberal judge on bail, there can be a little conservative judge. No judge can say anything on behalf of Supreme Court and other benches. So let us take from the middle side, yeah, girls, yeah. Yeah, please.
Good afternoon, Your
Just a minute. I'd like to respond to that. Let us be very clear. Nobody in this audience, except for judges, has even the slightest idea how the mind of the judge works. When you sit on the chair, when a matter comes before you, you can't imagine, we can't explain in words. That is the first point. Second is, you may label a judge to be pro-liberal, proactive. These are all misconceptions by the public. A judge may take a different view in the very similar circumstances, but then he justifies it, gives reasons. That is the beauty of the system. And when we say, just reverting back to the first question, the chief is the master, and once he allots, the judge is independent. And we have seen the judges deliver on the basis of the records, on the basis of arguments made, their mind is open, and ultimately going by the constitution and their conscience. So you should have the trust in the system. A judge is a judge. He should not be named as liberal, pro, conservative. It depends on the case to case. So that you have to be very clear, and then ultimately it is the trust factor, which is every time the press or the public judges a judge. It's not fair, especially from students of law and the audience which is so-called intellect. So you have to make a distinction and give that trust and benefit to the judge that at his place, when he is judging, he has a lot of factors which you are not aware of. He takes a holistic view. Every word from the Supreme Court makes a difference for the entire country in every other case which has to follow. Kindly keep in mind, and then probably you'll be able to get an answer. But there cannot be a complete answer. Thank you.
Correct. And my lord is right. You just saw in United States where at least we can definitely say that these are Democrat judges and these are Republican judges. But President Trump just lost a case when the majority of judges are the so-called Republican judges. Yeah, please go ahead.
Good afternoon, Your Lordship. Good afternoon, Your Ladyship. I had this question that Article 14 talks about equality and Article 15 talks about discrimination based on, prohibition or discrimination based on gender. But the very fact that even after 75 plus years of independence, we just had 11 ladyships in the Supreme Court. And as of now, Your Ladyship is on the Supreme Court bench as the only woman. The structure is there on the Constitution, but the on-ground reality in the courtrooms are very different. So something that can be changed.
In other words, you are saying that why women have not made it to the bench as such.
Yes, Lordship, and also your Ladyship, and also the fact that women don't prefer litigation.
Yes, the reason is, you see, because of the dual role that a woman plays, she has, please sit down. If she takes up a career in law, she also has her household to look after. That is why when I talk about myself, I say that when it comes to a successful man, there is always a woman behind a successful man. But when it comes to a successful woman, there is a family behind a successful woman. Why do I say a family? Because her responsibilities in the household is taken over by the members of her family. As a result, she can devote more time to her career, to her profession. Therefore, the visibility of the woman, the lady lawyer in the profession, becomes more critical for the purpose of elevation. That is why I have been saying that 30% of the law officers of the central government and Sir Advocate General, 30% of the law officers of the state government must be women, and 30% of the panel advocates in the public sector organizations must be women. If they are given an opportunity, they will continue to remain in the profession come what may. Their visibility in the profession would be greater. Then the Chief Justice will say, yes, yes, she has been appearing in my court, she does well. Why not consider her for the bench? It is because of this dual responsibility of a woman lawyer, and many a times she has to drop out from the profession midway or after her pregnancy and having a child, cannot return back to the profession, not have sufficient number of cases to attend to, and having this holistic, entire responsibility on her with regard to children, etc., that there are many women who do not ultimately continue in the profession for long, and they cannot be elevated as such. But the things will change, because in the recruitments which are going on now, more than 50% are women officers, and in due course of time, they will all come to the High Court, and from the High Court to the Supreme Court also. I am very, very optimistic, and I have a very positive outlook about it. Thank you.
Your Ladyship, that's where I have been arguing that the performance of girl students, particularly of national law universities in judicial services, is exemplary. But with this 3-year rule, many of them won't be able to write the exam. This will really will reduce the number of girls going into judicial services.
I don't agree with that, sir. Next year, I'll be completing 40 years in the bar, and I have so many things to learn. I have yet to learn. If students who come from the bench of the classroom to the bench of the court hall, they are losing out on experience. Please don't think losing 3 years is a loss of life. I am learning still at 40. Next year I'll complete 40 years after my graduation, and I am a student of law. If students are not able to stand before a judge, make an argument, seek a relief, how will you as a judge, as a lawyer that is, how will you as a lawyer grant relief? Don't think the 3 years of your life is lost. That is a very negative attitude you have. 3 years is not sufficient according to me. However, the Supreme Court has said 3 years. If a case is dismissed for default, what will you do? You will go and give your personal affidavit as a lawyer and seek restoration because a litigant has suffered because you have not appeared. If you have not done that as a lawyer, how will you grant that relief as a judge? When you go to the taluka levels, there are senior and senior advocates with 30, 40, 50 years of experience. You have come from the bench of the classroom to the bench of the court, and they will test you. They will make all kinds of arguments. If you have not been in the bar, how will you face the advocates in the court? You will not be successful. You will start crying on the bench. That will be a very negative aspect to your personality. Unless you get into the water, you cannot swim. Don't be under the impression that you have lost 3 years of your life. There are advocates and advocates who are learning, judges and judges who are learning even after 50 years. You ask them, and you don't want to practice for 3 years? This is not a correct attitude of the students who are saying that we are losing 3 years of our life. First, go to the bar, see how you practice, learn from your guru, your senior, how to be an advocate, whom you have to respect, how you have to learn the strategies of appearing in court. Unless you know the tactics and strategies of a lawyer, you cannot be a successful judge. If you want to be a successful judge, practice for more than 3 years in the bar, then write the exam. This is my advice to you. Thank you.
Next.
3 years.
Yeah, please go ahead.
No, brother, how many years you are there? Yeah, how many years?
Puche na.
One second. Our learned Advocate General has completed 47 years. And when he appears before the High Court or before the Supreme Court, he is facing, even now, certain naughty problems. 47 years of experience in the bar. And you want to lose that, even that 3 years of experience. That is not correct. Forget about 3 years. Even if you complete 6 years or 7 years, it is in your interest. Writing an exam, passing it by textbook knowledge will not take you anywhere. I am telling you, it is only practical experience in the bar, standing in front of the judge, addressing the court, talking to the client, speaking to an opponent, talking to the clerks, pending clerks, etc. in the court hall, getting your papers scrutinized, filing of a case, getting it moved, getting an interim order, arguing a final order matter will make you have some kind of a knowledge to write a junior division exam. Thank you.
I'll just add to that. Beloved sister has said many things. Yesterday in the General Council meeting also, this point was raised. And I want sister, you should understand that as a lawyer, you get an identity. This identity you carry to the bench. Straight away you come from college, you come on the bench, you don't have any identity. Why I am saying this? After retirement, you again get back as a lawyer. You don't know what this identity is. You don't know, you don't have the confidence. You don't know who you are and what is your duty. Unless you get a basic identity, and that basic identity is that of a lawyer, of an advocate. This identity you get only when you are actually in the bar, when you actually put in practice. That can never come through paper. It has to be undergone. There is no substitute or shortcut to that. Kindly remember, and this identity, this confidence, the initial years of practice is what makes your personality as a judge. You write it down, you understand, you ask your colleagues. That is a fact, as sister said. Even I can vouch, all judges here can vouch.
I'm very, I have strong views on this. Let me tell you this. A student from a bench in the law college goes to the bench of a court in a taluka headquarter. An argument is put forward by an advocate. How does that student know how to deal with that argument or what procedure to follow? She or he will look at the bench clerk. The bench clerk is already influenced by the advocate, and he will guide the judge. Sir, madam, aisa kijiye. You are going to follow the bench clerk, who is already under the influence of the advocate or the litigant. What kind of justice are you going to render? Unless you know what has to be done independently, you don't have to look at that bench clerk. You would remember what you did as an advocate when this situation arose, and you will apply that as a judge. Please take a vow that for 3 to 5 years you will practice and not sit for exams. Never mind, please see to it that your parents have the patience. They would have spent money on you for your education, but that is not the way that you must get a repayment immediately after you finish your course and become a judge. Yes, why we don't see as a matter of when I say when we interview for direct district judgeship, less than 35, they say we should not appoint such persons on the ground of suitability. Why is it there's an unwritten rule for High Court judges, it must be 45 years at least? Why can't Constitution says 10 years? If you have started your career, legal career in the High Court, let us say at 24, then at 34 you must become a High Court judge? No, that is there in the Constitution, but we wait till 45 years. Why? We require maturity, and maturity comes with life, with experience, with facing situations, not otherwise, not from textbooks, but by experience. A district judge can give a death penalty, but imagine if we appoint somebody who is 30 years with lack of experience, 32 years as a district judge, and he starts giving death penalty in all the POCSO cases because there is a death penalty provided and so many references in the High Court. What happens to our judicial system? See, all this is in order to save our judicial system in this country, that we want maturity in our judges, and maturity comes with experience. Please keep that in mind and don't be impatient. Thank you.
Yeah, any other? Yeah, Rahul?
I'm very strict about it.
Idhar mic de do.
No.
Sir, मैं
You say it, brother.
greetings.
We can take 2 more questions.
Okay. Greetings to the.
Yeah, please go ahead. Go ahead.
Greetings to the
Come to
all
the
of-
question. Come to the question.
Okay, sir. Sir, my question is for your leadership, ma'am. First of all, I just want to say that it's a great pleasure to see you here. And my question is that what kind of what kind of सजेशन विच आप लॉ स्टूडेंट्स को देना चाहोगे जिसमें वो थियोरेटिकल नॉलेज और प्रैक्टिकल एक्सपोजर्स के बीच में एक बैलेंस क्रिएट कर पाए. एंड मैम, माय सेकंड क्वेश्चन इज दैट एनी सजेशंस टुवर्ड फ्रॉम यू फॉर अस एज अ लॉ स्टूडेंट्स.
I have already given ample suggestions now for law students.
ओके मैम.
So what you must do is, you have already read in the law colleges, law college, all the laws you have read. Please, before you go to a senior's office, unless the senior is your father or uncle or somebody whom you wish to go as a junior, you go and sit in the courts, whether in the district court or in the high courts. Sit in several courts, see advocates arguing, then you select whom you want to go as a junior. Don't start your own offices on the next day after you get your enrollment. Put up a board, so-and-so advocate. No, go to a senior, learn from the senior. Don't start off your own office and say, I finished my law college, I've got my degree, I've got my enrollment, I've opened an office. You may have the economic capacity to open an office, very good, but you have not learnt anything from the senior or from what is happening in the courts. Seeing is believing. Learning from a senior is the best learning after your law college course. You are hearing an argument in court, try to read up on that in the law books later. If you are waiting for a case and an argument is going on in court, try to see, relate that to what you have learnt in college. Read it up. Read the section of an act or an enactment again and again. I am reading CPC again and again while deciding a case under CPC. Every time you read a provision, you will get a new insight into that provision. Don't go by memory alone. Reading the bare act, reading the provisions, application to the facts of the case. Please remember that don't start off on this happened in this case and this happened in this case, this is the law. Always be thorough with the facts of your case. Most cases, the law develops the facts. The facts of the case will generate the law. So don't go in the reverse direction. Read the facts of the case, understand the facts, then apply the law to that. Thereafter you come to case law. And mind you, don't go by AI generated case law at all. Go by the SEC, go by the AAR, go by the authentic reports. We had a case, Mercy versus Mankind. That case did not exist at all. Mercy versus Mankind is stated in the memorandum of special petition. The other side advocate pointed out, don't go by AI generation. Don't draft pleadings by AI. You can draft pleadings, maybe for list of dates and events you can take AI's help if you are going to the High Court. Feeding all the pleadings and getting a ready-made grounds of appeal or memorandum of writ petition, that is not correct. Please sit as far as possible. Now nobody writes. We all used to write the memorandum of first appeal, memorandum of second appeal, plaint, everything we used to write by hand. Now you can straight away type on your laptop. Do that. That will give you more insight in building up of the case. Thank you.
Here, last question, Rahul Shri.
Yes, ma'am. So my question is addressed to the entire bench. Given that the Constitution is an instrument of social justice, have we done enough to fully realize the role of social science evidence in constitutional interpretation? I ask this because in the US, for example, in Brown versus Board of Education, there have been conversations about the legitimacy of using social science evidence to arrive at their conclusion. And most recently in the Indian Supreme Court in Nitisha versus Union of India, they used psychological harm as to measure discriminatory impact. So would you say that this is a step in the right direction, and do you think we should be doing this, marshalling social science evidence more often in constitutional decisions?
No, it all depends on what aspect of the Constitution we are dealing with. See, ultimately it is every word of the Constitution has been put there after great deliberation and debate. Ultimately, if we want to interpret the Constitution, the best document we have is the Constitutional Assembly debates. Then the various interpretations that can be given. We all know that the Constitution is a living tree. It is dynamic, it is not static. Ultimately, our philosophy of the Constitution we always have while interpreting the text of the Constitution. Therefore, it is not always that we have to go by social science evidence on that. It may be helpful in, forming a kind of an opinion, but ultimately when we interpret the Constitution, it is the text of the Constitution which has to be interpreted.
Thank you. With this, we will close the Ayan, just last.
Hello. Your Lordship, before the great dissenter of the bench of the Supreme Court, I would like to put forth that by the court's own admission in the 2025 ruling, the best talent is often deterred from judicial services after 3 years of practice as they gravitate towards more immediate, stable careers in the civil services or the corporate sector. Considering that leading global jurisdictions, ma'am.
Yeah, it's okay. Well, she answered that question.
Yes,
Let's
no,
not
I
get
will
back to
also
that
say,
question.
see,
Yeah. Okay, it's okay.
Yes,
but your
what
ladyship, I would
what
like.
he's trying to say is, people who go to the services, who go to corporate jobs, who go to companies, immediately have a salary. But lawyers do not have that kind of a return as such. But please understand, lawyers belong to a noble profession. You are here to serve the litigants, and it is not, you cannot compare yourself with IAS officers, IPS officers. They have come up with their own passing of the exam with their talent, and after training, they are posted. You are of a different category. Don't compare. If an IAS officer has made a mistake, you as a lawyer will file a case to get that quashed. You are belonging to a different category altogether. So please don't think that a person who clears a UPSC or who is an IAS officer or a state government officer will get salary, a judicial officer will get salary, but I have to wait for 10 years to start my office. My senior does not pay. I have made only to work. There I can only say you must have patience. You must take the experience as your remuneration. And I must tell all seniors to look after their juniors. Don't exploit them. Pay them properly in terms of what they deserve for the work that they do. The seniors must look after the juniors apart from teaching them, pay them adequately so that the juniors do not feel that they are only exploited and they are not having any returns. So don't compare yourself with services or with any corporate jobs. If you want to be in the practice, don't compare. And you be in the practice, then you try your luck in the judicial services exam.
Thank you, madam. Just as
if I think probably we can expand your, we can
Ayan.
we can expand your question. I'll take it a step further. I think you also meant that because of this hiatus period, they think why wait, try for civil services to shift on. Was that also part of your question?
Definitely,
Yeah,
sir. And
So that I'll answer. The moment you join a law school, 5 years, that means you are focused in law. Don't have your eyes always the other side of the field is green. It is the grass is greener on the other side. Once you are focused, you want to law, you have to pursue, you have to keep either it is practice or in the judicial services. Don't look the other side. So don't think three years is like I already have a chance. Why not go to that side, keep law as a practice? Then that means you were never really focused in law. It was just a subject which fetches good marks, or probably it's good on a CV. Law degrees today are good. So unless you are focused, then you have to answer that for yourself. Whether you are really committed towards law, or you are focused, or you are not. So never compare, as rightly has been said by sister. There is no comparison. It is your conviction and your sense of duty towards what you want to give to the society and what type of person you want to emerge. Thank you.
Thank you. Just to end this interaction, no more, because they have flights. The curriculum has changed in the meantime. So earlier we had a 2-year law course, then it became 3 years, then it became 5 years. Each student of mine every year is doing 4 months of internship, invariably in the court. So they are not as fresh graduates as earlier used to be. Many of them are doing. The other problem is, and since our next speaker is His Lordship, I can say it what happened yesterday in GC. One of the reasons why the best students of NLUs do not write judicial services. Bihar is a different case. Here, public services are still very, very popular because they have to go to corporates because the fees of law schools are very high. So their parents have taken education loan. Unless we drastically subsidize legal education, we won't be able to force people to go to litigation and not earn enough. So I think there are a combination of facts with high unemployment rates. People take easy routes. So everybody cannot really afford to survive for 4-5 years. So that there are genuine cases where people have to write civil services or take whatever job is available. I had to take up with the Bihar State Public Service Commission the APO exam because many of my students came to me that they want that they should have their degree on 20th March this year. They are writing exam in April. How can I give them degree in 20th March? They said, we cannot wait for judicial services because exams are not held on a regular frequency. We cannot wait for, we want to get into the APO, aap kisi tarah just get this date extended. Then I took up the matter with the chief secretary, though that was not probably done. But there are people who are in huge financial difficulties. They have to get into some job.
No, sir, our response was in the context of this 3 years and joining the judicial service. If after the law degree they want to do UPSC, they want to do state service, they want to take up a job in, as an in-house or as what you call the council within the corporates, that is a different issue. They may join jobs. We are not on that. We are only on judicial service. If you want to join judicial service, 3 years of practice is a must. We are on that.
That's okay.
Yes.
So let me now, with this, end this.
Just a minute. London Advocate General was hinting at me
Acha,
that in Bihar, what he is proposing to the government for the students.
Yes, please, sir. वैसे आपको अभी आना ही है यहाँ पोडियम पे ही बोल के कैसे?
Recently, state government has approved a scheme to provide stipend of 5,000 per month to every newly enrolled student starting from 1st January 2024. That scheme I am likely to roll out in next 2 months. All nitty-gritty has been worked out. So hopefully, though it's a small amount, nonetheless, it will indeed support.
Yeah, something is better than nothing. Yeah, thank you. Let me now request His Lordship Justice Ehsanuddin Amanullah, sir. As I said that basically I am giving effect to his vision for CNLU. In the General Council meetings, he has been very strongly and forcefully arguing with the state government. Yesterday also, he said that the government should immediately issue the GO of our 7 additional acres of land and also handsome grants so that we get best of the infrastructure and we are able to recruit. Sir, we are really grateful that you found time for us and persuaded her ladyship also to deliver the first memorial lectures.
Thank you, Mr. Faizan Mustafa. Before I go on the formalities, good morning, namaskar, good morning, Sat Sri Akal, Assalamu Alaikum. I'm embarrassed when something is being talked about you, and that too in your home state and an institution of which I hold so dearly because my son also initially joined this institution. I think it is my privilege that I am in a position to do something for this institution because I feel a connect because of the state and because of the cause. And it's a great feeling when you see an institution develop. I've seen when first time I came with the Advocate General, he was also my Advocate General, he took me in his team, I was his choice. And then you see it grow and then you come in a position where you can help. The feeling is gives you a high. I feel because I'm committed, I don't have to show, I don't have to prove anything, but then it's a personal commitment for me for an institution, and for that matter, any institution. But obviously, your home institution is the institution to which you are committed. And before moving on to the formalities, I have to thank my dear sister, because I know how busy she is and what pressure she is and the amount of work we have. I know, so I can speak. As I said that nobody has an idea what is the pressure. I'll not say pressure of work because we all love our work. We are committed to the work, everybody, all judges, be it the High Court. But the sheer pressure of time, the volumes, the reading it goes. Ultimately what has to come out is your product. You are responsible. And I know how meticulous sister is. I was telling her that she'll give me a complex if I start what she does and how her routine is. Meticulous till the end, till the morning, preparing each and every word, every thought. So thank you so much, sister. And obviously, my dear friend and brother, Justice Sahu, who has been a real true leader for everybody, for the High Court, for this institution, they support the Learned Advocate General, and the Vice Chancellor, because he is a pushy fellow. He pushes at individual level, and this is what actually shows results. Pushing it at a personal level, everybody has commitments, so you have to keep prodding at the cost of being repetitive and also sometimes irritative, but still you have to keep pushing. So thank you all. My dear elder sister, Justice Nagaratna, Brother Justice Sangam Kumar Sahu, Chief Justice Patna High Court, brother and sister judges of the High Court, Mr. P.K. Shahi, Learned Advocate General, Madam Alka Sirohi, Vice Chancellor, Faizan Mustafa, Sir, Dr. S.P. Singh, Registrar, Judicial Officers, faculty members, senior advocates, student members, and members of the press. I really feel privileged to be amongst you for the first edition of the Dr. Rajendra Prasad Memorial Lecture. As has been said, he was a true son of the soil and he needs no introduction. He inspires, I'll pause here, reminds us that moral courage is the fiber of our constitutional ethos. Like you, I have also had the privilege of hearing my dear sister and propose to be brief. The theme of the lecture, that is Constitutionalism Beyond Rights, is apt given the world we live in today. As global events beyond our control unfold, it is important to be cognizant of what we value and cherish as a society driven by the rule of law, namely rights. However, are rights the only guarantee against possible excesses? When winds blow against you, who has courage to swim against the tide? While the Constitution in generic terms may be called a legal document, the spirit it embodies is constitutionalism. That spirit or soul ensures that rule of law prevails and not rule by law. In our specific domestic setting, perhaps the biggest example of an extended philosophy of constitutionalism can be found in the position of the basic structure doctrine. Ours is a country of diversities. Not for nothing is the phrase unity in diversity considered apt for the nation. It is not just a slogan. It is our lived and shared reality. We are an ancient country with a young population. We have various groups competing for various rights before a mighty state. The bulwark against the state is constitutionalism. The state thus moves from being an instrumentality of executing its own vision to a participant in unleashing meaningful social change. In other words, the abstract of the Constitution is translated into reality by constitutionalism. In terms of the legal profession, judges, lawyers, academics in law need to be at the forefront of sensitizing the society at large about the issue, inasmuch as while Article 32 or 226 of the Constitution of India may be what is seen conventions, practices and traditions, all rooted in constitutional morality, form part of the unseen. The silences of the Constitution is another area where the voice of constitutionalism has to be resorted to. A case in point being BP Singhal versus Union of India 2010-6 Supreme Court cases 331. The way these silences are heard and answered is how the Constitution transforms from document to destiny. Ours is a unique governance structure, not fully unitary nor fully federal. It is a mixed, a creature of its own in the midst. Yet, cooperative federalism is also part of the basic structure. Howsoever strong the center may be, it cannot always impose its executive will upon the states, especially in matters of daily administration. Likewise, in matters of foreign policy and the like, the union's fiat prevails over the states concerned. This delicate and balanced equilibrium is no accident. It is a deliberate design by the framers of the Constitution. Yes, a completely textual reading of our Constitution makes it seem as if there is a strong affirmation towards the center akin to a unitary governance model. To borrow from the American context, an originalist and a textualist approach would stipulate that the Constitution be always interpreted keeping in mind the legal and social scenarios of the time it came into being. Happily, Indian jurisprudence has not been found caught in a time warp when it comes to this. The Indian view did not freeze its thinking in the past. The Supreme Court, our Supreme Court, has called the Constitution a living document. In embarking upon interpretive exercises, our court has not lost sight of contemporary legal and social settings. It has refused to be a prisoner of history, but chosen to be a proponent of the future with a keen gaze on the present. I am tempted to offer a comment in relation to the issue of withheld, delayed assent to bills by certain governors. However, in view of the fact that 5 distinguished colleagues of mine have recently offered their views to the President by way of answering a special reference, I refrain from doing so, being conscious of the post I am currently holding. Ladies and gentlemen, our understanding of constitutionalism has also traversed from procedure established by law to one akin to due process of law, essentially mandating that procedure itself must be fair, just and reasonable and not illusory. The states and its agencies, though entitled to certain leeway in certain matters, are not left unconfined to act as knights errant. Their actions remain under the watchful eyes of the sentinel on the qui vive. As such, procedure is not just a formality. Rather, it is what acts as a barrier between right and wrong, just and unjust, legal and illegal. Like justice is undefined, nirankar, I would say even the Constitution is nirankar. It has to be molded into the situation, the requirement of the day. It is fluid. That is why it's called a living constitution. Every day in a body like a body, your blood pressure rises, it comes down, your oxygen level comes down. The constitution expands, shrinks, becomes restrictive. So all the time it is dynamic, fluid, adapting the body to which it is required to be fit into. There are no defined boundaries. However, the spirit and object remains constant. Basically, it is in public interest to uphold the law and most of all to do complete justice without any shackles. Let us again revisit. I keep telling, even for the bench recently I observed that today probably we are more doing lip service by upholding the Constitution while forgetting what the spirit is. And it's a body without a soul, body without life. So if you take the spirit out of the Constitution, it becomes just a mere book to be read like a statute. Now the trend is a little bit disappointing. I take full responsibility being a judge also, that probably due to lack of time, the pressure constraint, dependency, because to interpret the spirit takes a lot of thinking, calmness, time. That is what judges don't have today. The pressure which they are working, the expectation of the public gaze, the media scrutiny, then the government being the biggest litigant. But time has come that, speaking for myself, I have never bothered for numbers, no statistics, no disposals. Each case for me is as important as the other case. If I think I have to give a thought process, I emphasize more in that thought process rather than moving on to another case. That probably is a course correction which at this juncture is the biggest challenge before the judiciary, because on the one hand you cannot abdicate saying that I have no role, disposal is not my botheration, because numbers do count. We are accountable to the people. They are waiting for justice. They have come to the High Court or the courts. We cannot abdicate, but at the same time, if really the Constitution has to work, the country has to flourish as a unitary body where rule of law prevails, where people are assured that no matter what the might of the other side is, if their cause is right, nothing can stop them from getting their cause. That confidence has to be rebuilt, and I think, I am very sure that the onus more is on the judiciary. Thank you. Jai Hind.
Put it in a very short way.
Thank you very much, my lord. Brief and impactful speech. I would now request our own Chancellor, His Lordship Justice Sangam Kumar Sahu, Honorable Chief Justice and the Honorable Chancellor of CNLU, to deliver the presidential address.
Very well said. The Constitution is now not as alive as it used to be earlier.
Pranam. Honorable Mr. Justice B.B. Nagaratna, Judge Supreme Court of India, Honorable Mr. Justice Ahsanuddin Amanullah, Judge Supreme Court of India, Professor Dr. Faizan Mustafa, Vice Chancellor, Chanakya Law University, National Law University, Learned Advocate General, Mr. P.K. Sahi, my esteemed colleagues of Patna High Court, Learned Registrar General and members of Registry Patna High Court, the Registrar and members of CNLU administration, distinguished members of the faculty, members of legal fraternity present here, my young friends, the students of law, members of print and electronic media, ladies and gentlemen. First of all, I convey my sincere thanks to the learned Vice Chancellor for organizing this first Dr. Rajendra Prasad Memorial Lecture and for doing so in the distinguished presence of two honorable judges of the Supreme Court of India. I also thank both the honorable judges for giving their valuable time for this lecture. What we have heard from the two honorable judges, it was just amazing. And the exceptional presentation, the inspiring talk has not only broadened our knowledge, but has made a significant impact. I'm sure the law students who are here and watching this program online will be immensely benefited. Now, so many things have been stated about the distinguished personality in whose name the memorial lecture has been organized, Dr. Rajendra Prasad. As has already been told that he was not merely a politician, but he was a lawyer, a journalist, a scholar, and a statesman who served as the first president of the Republic from 1950 to 1962. And he has got immense contribution to the nation building and social reform. He came to the public life through Indian independence movement, rising from one of the foremost leader from the soil of Bihar, and a devoted follower of the father of nation Mahatma Gandhi. He quoted imprisonment by the British authorities during Salt Satyagraha of 1930, again during the Quit India movement in 1942. And as has been told that after the Constituent Assembly election of 1946, he served as the India's first Minister of Food and Agriculture. And when independence came in 1947, it was Dr. Rajendra Prasad who was elected as the President of the Constituent Assembly of India, guiding with quiet wisdom and uncommon grace the drafting of the Constitution that governs us even today. He was known as Desh Ratna, jewel of the nation, and Ajata Satru, one who with no enemies, and affectionately called as Rajan Babu and commonly referred to as Bihar Gandhi. Henry Wadsworth Longfellow, the poet, has said, lives of great men all remind us we can make our lives sublime and departing, leaving behind us footprints on the sands of time. This Constitution is not at its core a catalogue of liberties. It's a document that gives birth to the state. It creates organ of governance, distributes power among them, and sets the limit on what each of us may do. The most important provision of the Constitution of India are not the fundamental rights guaranteed under Part 3 or the fundamental duties as mentioned in Part 4A, but also the provisions which deals with the parliament, the executive, the judiciary, and the federal relationship between the union and the states. Constitutionalism is something beyond the document itself. It is the conviction of the governmental authority must derive from and be exercised in conformity with a body of fundamental law that binds even those who wield power. Aristotle distinguished between the good polities and the corrupt ones, not by the content of their laws, but whether those who governed were themselves governed by law. So that is the seed of the constitutionalism, not merely that the Constitution exists, but that it is genuinely followed. Constitutionalism is enshrined in the Constitution of India, which promotes justice, liberty, and equality for all the citizens. It emphasizes the rule of law, separation of power among the different branches, and checks and balances to prevent abuses of the authority and protect the citizens' freedoms. It aims to prevent arbitrary rule and promote accountability, ensuring that both government officials and citizens adhere to the law. We live in an age that has made the rights the primary language of constitutional discourse, and rightly so. But there is a risk allowing this focus to crowd out everything else. We may begin to concentrate so deeply on the rights as ends in themselves that we lose the sight of the condition that makes the rights effective. Rights are promises, and the structure of the Constitution is the means by which those promises are kept. The structural side of the constitutionalism includes those features of the constitutional system that make it possible to protect the rights and hold the governments accountable. The separation of the power, the independence of the judiciary, the federal distribution of the authority, free and fair elections, and the mechanism of the checks and balances that prevent any single branch from accumulating power without accountability. These structural features are the load-bearing walls of the constitutional edifice. They are invisible to the person living in the house, but remove them, everything falls. Liberty depends not on what law says, but on how the power is arranged. Where legislative, executive, and judicial power are concentrated in the same hand, there can be no liberty. Whatever the law proclaims, and as the architects of the constitutional democracy well understood, in framing the government which is to be administered by the men over the men, you must first enable the government to control the government, and in the next place, oblige it to control itself. That phrase, oblige to control itself, is the very essence of the structural constitutionalism. Now, several decisions which Honorable Madam Justice has already referred to, and those are based on constitutionalism, and Vice Chancellor has referred to. So I don't want to repeat those decisions. It starts from that Keshavananda Bharati's case, Indira Nehru Gandhi case, Minerva Mill case, then S.R. Bommai case, L. Chandra Kumar case, and of course the NJSC case. These decisions taken together, a true oath stating plainly that the rights are almost always defended through structural doctrines, equality is protected because arbitrariness is checked. Liberty is protected because detention is answerable to the courts. Dignity is protected because power is distributed. The strength of the right depends on the health of underlying structures. And I will conclude that you cannot protect what you cannot see. The structure of a constitution is invisible unless it breaks. Right cases are visible, they are reported, debated, litigated, but the slow erosion of the structural safeguards doesn't produce a single dramatic moment of violation. It works like a slow leak, and by the time the damage is apparent, it may already be deep. This is why the duty to protect constitutional structure falls especially on the courts and on lawyers who appear before them. Dr. Rajendra Prasad, as he watched the Constituent Assembly complete its work, knew that what he was witnessing was not a conclusion, but a beginning. And every generation would have to choose institution by institution whether to honor the structural commitment that Constitution embodied. Those who work for the Constitution must first understand it, not merely the right it declares, but the structure it erects, not merely the liberties it promises, but the architecture of accountability it builds to make those promises credible. This institution in which you are reading is named after Chanakya, who is regarded as a great thinker and diplomat. As student of law, I request all of you to read at least two books which are attributable to him. One is Arthashastra, the other is Chanakya Niti. Dear students, before parting, I would just say that don't read Constitution only for the rights it contains. Read it for the structure it creates. Understand why that structure exists and defend it when it is threatened. A constitution without structure, a constitution without a structure is a crown without a king, ornamental perhaps, but capable of governing nothing. You are all brilliant students. That is why you got selected to be taught in a national law school which ranks 7th in our country. And students like you, if you come to join the legal profession, the bar standard will grow. will able to hear quality argument, will get quality advocates, and when bar improves, ultimately from you, the judges will be selected. So that is how the judgment quality will be improved and there will be good judges. So at this juncture, as you expressed, there may be little problem regarding financial aspect, but as ma'am has already said, keep patience, just learn. The qualities of advocacy you learn, and that will ease everything. We know that what sort of struggles in our generation we are doing, and you are very lucky that you are having these laptops, these Manupatras, SCC. When we are told to find out a decision, we are to go through those notebooks and even pick one book by other. And the senior would tell that you should get the decision by the next morning. So that was the struggle period for all of us who are sitting in the front and on this dais also. So it has become easier for you, and since the scope is now available, have the patience, you will definitely succeed. And remember, friends, that there is always a place for those who are laborious, those who are honest, those who are truthful at the top. Thank you very much. Jai Hind, Jai Bihar.
Thank you very much, my lord. I would now request Shri P.K. Shahi, our learned advocate general, who is a mentor of our university, a kind of a founder of this university, who is a link between university and the government. And at times I feel embarrassed when I go to him and ask him to call bureaucrats for some money for the university. Sir, we really acknowledge your help and look forward to your continuous patronage of the university.
Namaskar. Honorable Justice B.V. Nagaratna, Honorable Justice Ahsanuddin Amanullah, Mr. Faizan Mustafa, Vice Chancellor CNLU, Honorable Judges of Patna High Court. I am stopping at this stage because in political conferences and meetings, the thanksgiving, by the time it started, listeners had already left. However, I find distinguished listeners present here. So, faculty of CNLU, my dear students, friends from media, it is indeed a privilege that as a true tribute to a great freedom fighter, a constitutional architect, President of India, Dr. Rajendra Prasad, that Honorable Justice Nagaratna has graced the occasion and has enlightened all of us, not only in regard to Constitution, but the structures. Needless to say that not only Constitution, democracy itself will collapse if structures do not exist. And a structure should exist independent of individual, not that the structures keep changing with the change of individuals. So the structures protect the democracy, it protects the Constitution, or else we have seen fate of democracy in different parts of the world. Justice Nagaratna has elaborately discussed. My Lord, I express deep thanks on behalf of the State Government of Bihar and on my behalf, with a request that you keep coming to Bihar. It's a land, it's a cradle of civilization. it is, my lord, it is confluence of different religion. And after 25th of November 2005, Bihar has scripted a turnaround, and that turnaround is very significant because Bihar is a unique state where revolution has taken place in women empowerment. You'll be surprised that number of girl students in matriculation and +2 has far exceeded boys students. The entire rural landscape of Bihar has transformed. It is for anybody to go and travel to every nook and corner of the state, and you will find every market over flooded with women, at least 1.5 times more than male. So this is the change. My lords, change do not always occur because of industrialization of a state. It is civilization, it is, my lord, change of society. We are a state of roughly about 13 crores. I still remember when in Florida, I was addressing a gathering of all US. They have a different kind of system. Community College Association. I introduced and I told them that I have 20 million children in the age group of 6 to 14 studying in government schools. The chancellor couldn't believe me. He interrupted me and asked me to check the number. So we are a state of more than 13 crore living in an area of 94,000 square kilometers. However, we are progressing and we are marching ahead, and I'm very hopeful that future of the country lies in Bihar. So I would request ma'am to visit again. I'm very thankful that with this we have remembered Dr. Rajendra Prasad, who has almost been lost. I'm anguished and I was pained that on this year, on his Punya Tithi, I went to Jiradehi, where he was born. His memorial is preserved by Archaeological Survey of India. And I was aghast that for last 1.5 years, it has no electricity connection. No electricity because bills have not been paid. When I inquired, district magistrate informed me that we can't do anything because Archaeological Survey people are not allowing us even to touch it. So I immediately took steps. I asked the government to get approval from Union of India, leave this Archaeological Survey only to keep a watch. We will develop it. So a great leader, a freedom fighter, an architect of the nation is left so ignorant that we need to keep reminding new generation that how important Dr. Rajendra Prasad has been for the nation and more than that for the state. My lord, I need not thank Justice Amanullah. He is doing his duty. Where he is, he owes it to, my lord, this state. I appreciate what he is doing, not only for this university, for the state as a whole. He keeps conveying his concerns about the state's development. It is really heartening that what is expected of somebody adorning the highest seat, that he keeps, my lord, track of his own state. I thank him for what he has been doing. Chief Justice, my lordships, Justice Sangam Kumar Sahu, he has come only recently. However, with his hard work and innovations which he has introduced, it has made a deep imprint, left a deep imprint on the functioning of judiciary. Not only, my lords, adjudication skills, he is very concerned about, my lord, states many important issues. Recently, he has himself taken upon the task of strengthening, my lords, mental health of the state by taking upon a pro bono matter and issuing direction, visiting mental hospital himself. He is introducing, my lords, making the court paperless. So all these efforts, my lords, needs to be thanked for what he has done. I don't think that he should be thanked for what he is doing for this university, because it is again his duty as Chancellor. I am extremely thankful, my lordships, that all honorable judges have spared their time on Saturday to be present in this conference. All distinguished faculty of CNLU, and more than everybody, the students' presence, I acknowledge and thanks. I thanks the friends from media. Thank you all very much.
Thank you so much. With this, we close this program of first Rajendra Prasad Memorial Lecture. And next year, we will have another speaker. And I hope that this series will continue and we would be able to bring out in print the text of the lecture. Thank you very much. God bless you.